What is a severability clause in my contract? My name is 𝙃𝙀𝙍𝙀𝙊𝙒. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Today let's take a look at one of those clauses that's at the end of your contracts. Normally it's one that not a lot of people have questions about, but it's important that you understand why it's there and what it does. So whether it's the first contract you've ever received, or if it's number 100 for the day, you've probably seen a lot of different contract clauses whenever a contract is given to you. Up front, you'll see information about who the parties are, payment terms, how long the contract lasts. We can have non-disclosure agreements. We can have intellectual property agreements. We can have tax statements. There's all kinds of different provisions that are in your contract. As we get near the end, we have some common provisions that you'll see throughout what we call the miscellaneous article. Things like a jurisdiction clause, which says where disputes will be heard. There can be an arbitration or mediation clause that goes with it. There can be notices clause saying where notices have to be sent and how they have to be sent. And usually in that set of clauses, you're going to find today's topic a severability clause. It's usually near the end of your contract, and it's an important clause for you to understand why it's in there. It's not just one of those boilerplate provisions that gets left at the end of the contract. So a severability clause will usually say that if one provision of this contract or one part of the contract or any number of parts are found to be unenforceable, maybe a court rules it's unlawful or there's some other problem with that clause, that it does not invalidate the rest of the contract. So this can be important because you can have a lot of different clauses in your contract that you need to have survive even if one part of the contract is not valid. Otherwise, and without a severability clause, if the other party could find one problem wrong with the contract, they could throw out the entire contract if it wasn't included with a severability clause. They could say, well, here, Judge, this one piece of the contract is invalid, therefore the whole contract is invalid. Now, that may not seem very logical to you, but back in the day when we started doing breach of contract cases, there's a reason we started adding these clauses, and that was because some courts would find that if one provision of a contract was invalid, the whole contract was invalid. So then those smart lawyers back in the day said, aha, wait a second, we have an idea. What if we have a provision that says, okay, if this one clause is invalid, that does not mean that the rest of the contract is invalid. Since that time, we've seen severability clauses in almost every contract of any consequence. So if you've been given a long contract, look near the end and you'll probably see there's a severability clause in there somewhere. So the key components of the severability clause are twofold. The first is that there has to be an assertion that the contract provisions are independent of each other. So that, for example, if one provision is invalid, the rest of the provisions are not invalid. Let's say the notice provision has the wrong type of notice and it wouldn't be a valid notice provision under law. We still want the rest of the contract to be held to be valid. Or let's say there's a jurisdiction clause that says all cases have to be heard in Japan. Well, the court could find that the Japanese jurisdiction clause is invalid, but using the severability clause saved the rest of the contract so that you are not out of luck if there's a problem with that contract. And the second part of the severability clause will be a statement that says that if one of the clauses is deemed to be invalid, the contract still continues in full force and effect. So one example of what a severability clause would look like would be the invalidity or unenforceability of any provision of this agreement shall not affect the validity or unenforceability of any other provision of this agreement, which shall remain in full force and effect. Now that's just a basic sentence taken from one of the contracts that I use. You probably have a similar verbiage in a contract you're working with, but it all comes down to these key components, making sure that we say that each contract provision is independent, and if one contract provision is found to be invalid, the rest of the contract can remain a valid contract. So the severability clause is one of those things that you don't see litigated very commonly. It's become pretty much accepted practices in our contracts that we're going to have this severability clause so that we don't have to worry about contracts being thrown out for one little typo or one little provision. If you have more questions about clauses in your contract or you want to discuss a severability clause further, you can go to my website, 𝙃𝙀𝙍𝙀𝙊𝙒. There's a red legal strategy session button on the front page. You'll be taken to my scheduling page where we can set up a phone call, usually 15 or 20 minutes, and we can go through your questions and go through issues you may be having with clauses in your contract. If you like this video, you can hit the like or thumbs up button below. You can head over to YouTube or 𝙃𝙊𝙇𝙊𝙒 and subscribe for future videos. And you should remember that there's a whole bunch of clauses like this at the end of your contract, usually in the miscellaneous article, but just because they're back there and just because they're in every contract doesn't mean they're not important, and you should know what they mean and how they affect your contracts.